This is Dean.
Dean?
Yeah.
Okay, two things. Yes, he's going to let you appear by phone.
All right, just a second here. All right, what'd you say?
Okay, first, two things. First, she's going to let you appear by phone. I'm going to take the phone in there and put it on speakerphone.
Okay, are we in chambers or where are we at?
We're in the courtroom, but no, I'm not. I'm outside the hall right now talking to you private.
Oh, okay.
Okay. And then the second thing is your statements that you made before you were arrested at your home. Do you have any objection to those coming in?
What statements are you talking about?
When Buchanan and Robinson, the detectives, talked to you outside before they arrested you.
Well, they didn't talk to me before they arrested me.
You were out there telling them about things before you got arrested.
I was in the driveway talking to McCoy, telling him about pain.
You object to those statements coming in?
Yes, because they're even false. You even see in the breach video, I'm pointing over to the stupid shell casings.
No. I'm saying, do you object to your statements coming in, where you were doing all that, pointing out and telling them what happened? That's the question.
The question, all right, hear me out. You've seen the breach video.
Yes.
And then the med truck pulls up.
Yes.
That's when I was telling McCoy that Payne attacked, and I pointed over to the fire hydrant.
That's fine. Do you object to that coming in?
I'd have to reread it, but he put in that stupid, he just made it up. He put in that evidentiary harpoon, which didn't happen. And it's obvious when you see the breach video, he's lying through his teeth. He even testified he never went into the house. He did.
I understand. The question is, do we need a Jackson Deno hearing on whether it was a voluntary statement? That's the issue.
Yes.
You want the Jackson Deno hearing?
Yes.
Okay, fair enough. Your Honor, I have Mr. Black on the phone.
We are on the record. CF 2020-65.
May I stand here with the phone, Your Honor, so you can hear it?
You can put it down. You probably can just set it down and he can't. I'll ask to make sure he can hear it. We are on the record in CF 2020-2265, State of Oklahoma versus Dean Black. Mr. Black is present via telephone conference, represented by his attorney, Warren Gocher, who is present in the courtroom. The state is present and represented by Aaron Graywood. This matter comes on for status of the defense's motion for continuance. Before I proceed, Mr. Black, can you hear me?
Yes, it could. I don't know if the speaker can be placed, or I should say the phone could be put somewhere better. I can hear you, but just a little bit garbled. You know what I'm saying?
Okay, I will. I'm going to have my clerk hand it. She's setting it right by my bench. Let me ask, can you hear me better now?
Oh, much, much better. Thank you.
You're welcome. And we may, just so you know, obviously I'm not allowing your attorney or the state of Oklahoma to stand up here next to me at the bench. So before I hear argument from them, I will pass the phone so that you can hear what they're saying. But when I'm talking, I'm going to go ahead and keep it by me, okay?
No problem. You actually sound very good right now, just FYI.
Okay, thank you. So what we are here for today, and Mr. Black, I know that this case did not make OSCN. I will tell you, your attorney filed a motion for a continuance, and so that we could address this before Monday's jury trial setting, I just added it to my docket today at 10, which is why it's not on OSCN, okay?
Okay, that's fine. I looked to double check. I didn't see it. And Judge, just FYI, all this came up just here in the last few days as well, as Mr. Gocher articulated in his motion for continuance, which I read. I don't remember what time it was, probably 4 o'clock this morning. I've been up all night, by the way, working on computers, working on this, going to computers, working on this. You understand?
All right. Well, let me stop you there because I'm gonna stay focused on what we're here for today.
Yes.
Starting with the motion for continuance. Again, I have received that. That was filed on October 25th, 2023. I'm going to allow the state of Oklahoma, excuse me, an opportunity to state whether or not they would agree to a continuance or if they object to a continuance. So, Mr. Graylis, I'm going to ask.
We would object to the continuance. We are ready, have been ready. This has been set for many months. I think all parties are prepared. I noticed the motion to file on behalf of Mr. Black by Mr. Gocher does not indicate he's not ready. Just that Mr. Black would like to for a continuance. I don't believe that is cause for a continuance. The state's ready to proceed on Monday.
Right. And Mr. Gocher, do you have any additional argument that you wish to make with regard to your motion for continuance?
Your Honor, Mr. Black has concerns about my ability to be prepared. Mr. Black is absolutely correct in one thing, that I started a jury trial October 16th. A suit that lasted 4 days. I got out of that trial and I started a jury trial in Skokie Federal Court on the 23rd that lasted 3 days. Mr. Black was advised, I think, that I had these trials, but it probably did not register with him. And he feels that because I have not been in my office that I am not prepared. I will tell you, like in all cases, I think I have done preparation, but Mr. Black did not think I have. In his case, I could always use more time to prepare. I think that's about the best I can say.
All right. So with regard to the motion for continuance, just so that the record's clear with a little bit of history in this case, obviously this is a 2020. Oh, Mr. Gocher, yes, sir.
Could Mr. Black be heard on this, if you don't mind, Your Honor?
No, he does not need to be heard. So I'll note your request, but I'm going to deny that. All right, this matter is a 2020 felony. It first appeared in the court system June 18th, 2020. Made it up to district court. Looks like finally February 1st, 2021, which is the first date that Mr. Black was set in front of me. On February 20, and then we had COVID hit, so there was a lengthy delay because of COVID. Finally, back on February 28, 2022, the matter was set for jury trial December 12, 2022. Looks like December 5th, 2022, Mr. Black indicated that he was potentially going to be hiring a private attorney. The court granted a continuance of jury trial at that time so that Mr. Black could hire private counsel. Finally, we get to April 10th, 2023, after we had several settings where Mr. Gocher was present with Mr. Black. And again, on April 10th, 2023, the matter was set for jury trial on October 30th, 2023, which is Monday. We had several status conferences between April and today's date where Mr. Black and Mr. Gocher were present. In addition, Mr. Gocher delivered a defendant's exhibit book that I will tell you the entire time I've been on the district bench, this is the only time that I have had a well-prepared, well-thought-out exhibit book presented by defense. I don't get this even from the state of Oklahoma. This is something that one would see more in a civil trial. So it is abundantly clear that Mr. Gotcher is prepared, has worked on this case. Therefore, I am going to deny the request for a continuance in this case.
I'm going to object.
Sorry?
Judge, I'd like to object to that, and I'd like to present my part of this. I've only spoken about this case a couple of times with Mr. Gotcher, even in the last month. I have not seen him since the last time we were in court. I have not even seen him. The exhibit book that you are currently talking about was actually prepared by his, I guess you'd call it paralegal. That's Shelley. I've spent more time on the telephone with Shelley preparing the exhibits, which are incomplete because they require Mr. Gotcher's approval or whatever before he puts them in there. So I sit around and I talk to Shelley and I say, I need this, that, and the other thing. And then she says, well, I got to get with Warren. He's in court. I've been going back and forth about this, and this gets back to, about you were present in the courtroom when I got upset the last time I was there. Actually, I think it was the time before last. And because let me just say this, Judge, I don't want to lay any more aspersions than I have to, but on July the 6th of this year, Mr. Gotcher did not even know who Bailey Cheek was, and I am not joking. He is not prepared for this case. There are many more exhibits that need to go into that record. I made a list of about 30 just this morning, probably at about 6 a.m., and I have not heard back on those because I think Mr. Gotcher was on his way to Tulsa.
All right, so here's where we are at, Mr. Black. I am denying the request for continuance. You can proceed on Monday with Mr. Gotcher as your attorney, or you can proceed pro se. Either way, this trial is beginning on Monday, October 30th at 9 o'clock in the morning. I will note your exception to my ruling with regard to your denial of the continuance, but we are proceeding on Monday, October 30th.
See, this is where you realize the position you do put me in, Judge. And not only that, I brought up, you went through a whole list of things earlier, and I even had a recusal in, and I haven't waived that either. And I have my objections on the record on certain things. And I honestly, Judge, I actually hoped the best with you. I honestly did. I honestly did. But this case is political in nature, and if you want to insist on a trial, I am stuck with an attorney that is not prepared. He does not know the facts of the case. He has basically come up with a one-paragraph summary on his own. He hadn't even looked over the J. Long stuff or anything else, because he'd been working on a number of cases, including the Glossop case, I found out. He was even working on that back in, March, April, May, there in that time frame. I didn't hear from him for 3 months back then. I was complaining about it the entire time. And I ended up having the disagreement that I had with him in the courtroom that day. I guess that was that the last one or the one before last? I don't remember. Can you refresh my memory? It's kind of a cloud.
I don't recall, but again, I've overruled your request for a continuance. So we have other matters that we need to discuss. I don't know if you have talked to him about the audio between himself and Sergeant Buchanan and whether or not he's going to object and wants a Jackson Deno or not. If he does, then we need to set that for Jackson Deno.
Yes, need to hear that too, because I'm gonna tell you something else, Judge, about that Buchanan audio. One, audio has been withheld. There were 2 meetings with Buchanan where I was describing the actions of Hayden Payne. They aided and abetted Hayden Payne. They let him escape. They couldn't have indicted him for illegal parking in front of a fire hydrant. The reason my case has gone on and on and on is because Payne skipped bail, and they ended up basically leapfrogging my case with Hayden's case while he skipped bail and went to North or South Carolina or wherever that was. And not only that, I have found out through the discovery stuff, and I have identified a specific person that was actually on site with Hayden Payne at the time of the shooting where we almost got killed. There was somebody else on the scene, and I have identified him by name, and the state has failed to do a proper investigation even to identify that person. There was another man that they were chasing around the neighborhood and even called in air support to find this guy running down Hemlock Street. And it says on my initial filing or statement of probable cause, wrong defendant arrested. I requested habeas corpus twice that day. At 2:45 p.m., I knew that they had arrested the wrong guy. At 2:45 p.m., the state has not disclosed that telephone recording at 2:45 p.m., even though they document it in the documents that were disclosed in the internal jail calls and stuff like that. It was one of the jail calls. Very first one, 2:45 p.m. I requested habeas corpus then, and at 7:22 p.m. that night, when they talked about not letting me talk to counsel because of COVID, I demanded a federal habeas.
I'm going to tell you, I'm about to mute you. I'm going to set this matter for a Jackson Deno hearing October 31st at 9 o'clock in the morning. So we will set this for Jackson Deno October 31st. We'll get our jury picked on Monday, and then we'll have a Jackson Deno hearing first thing Tuesday morning with regard to this audio. The other thing that I want to talk to you about before we go off the record is I know that Mr. Graylis has not made a recommendation in this case that you wish to accept, Mr. Black. I did tell your attorney that I would be willing to allow you to do a blind plea in this case. Blind plea means there's no recommendation from
I'm innocent, Judge. I'm even the wrong defendant arrested.
Can I just explain to you what the rec would be and make sure that you are making an informed decision? I'm not asking you to accept the recommendation. I just want to make sure you understand what I'm willing to do in this case for you.
Okay, let me,
okay?
I already understand what you mean, okay? So I'm not cutting you off, Judge. I'm acknowledging your statement. I know what you mean by a blind plea, okay?
Let me for the record state what that is. Ordinarily, on a blind plea, the court would not tell either the state of Oklahoma or the defense what I would do in this case. However, I want to make it abundantly clear to you because, again, this count carries up to life in prison. And I understand it would be taking a leap of faith if you enter a blind plea without a recommendation, because the court could potentially put you in prison for up to life. What I have told your attorney in the state of Oklahoma is this: if you want to enter a blind plea, and I will allow you to do a no contest plea, which means you are not admitting that you did anything wrong. You are simply acknowledging that the state anticipates its witnesses will come in and testify as the state anticipates, and there would be enough evidence for a jury or a finder of fact to find you guilty. However, I would be willing to do a no contest plea and put you on a one deferred, meaning you would be on probation for 1 year. It would be unsupervised at the end of the 1 year period, assuming you do not violate any city, state, or federal laws, which I do not think would be a problem for you, Mr. Black, because this is the first contact that I have seen that you have with law enforcement. So in 1 year, you would come back, and this case would be dismissed and expunged off of your record. Do you understand what the court is thing would be the sentence if you entered a blind plea with a no contest plea.
Yes, I understand what you're saying.
And you also understand that if you go to trial and a jury finds you guilty beyond a reasonable doubt, they will have the range of punishment up to life. You understand that?
Yes, but I would also like to note in the record again, Title 21 OS 1364 is a bill of attainder. I cite the the lawful cause jury instruction, which references the OSBI versus war. Actually, it references the licensing regime of Oklahoma, which covered under New York Rifle versus Bruin. That's the bill of attainder. It is under 1364, which is discharge. If you remember the motion to quash that Mr. Boheim filed, he even said, is discharge a crime? In other words, self-defense. In Oklahoma law, discharge 21 OS 1364 is in fact a bill of attainder governed under the bill of attainder clause of the Oklahoma and federal constitutions, as well as the Indian Civil Rights Act, as the case may be in this screwed up state that I call Yugoslavia now. Even under the ICRA, it's a bill of attainder, and you can refer to OSBI versus Warren. 1364 is discharge, and it refers to the licensing clause of the licensing regime, specifically cited as a bill of attainder in OSBI versus Warren. That was what, 97, 98? You can pull it up and see what I'm talking about, Judge. The prima facie, the Supreme Court of Oklahoma has already declared Oklahoma's Self-Defense Act is unconstitutional as a bill of attainder. Those are the words of the Oklahoma Supreme Court.
Okay, so here's what I'm going to do. I would like for you to visit with Mr. Gochart. I'm assuming at this point in time you are telling me you do not wish to accept or enter a plea in this case, correct?
Here's what I would like to say to the judge, Judge Moody.
Yes.
I've been talking about this with Warren for several days, actually for quite a while, because we keep talking to Grayless here, and no offense to Mr. Grayless, but Mr. Grayless's signature is not the signature on that information. The signature on that information is actually Mr. Kunzweiler. Mr. Kunzweiler is Mr. Grayless's boss, Mr. Kevin Keller's boss, Delinda Jeffers' boss, and Kenny Elmore's boss. I would like a meeting.
I am going to cut you off and redirect you. I asked you a yes or no question.
And what?
Do you want to enter a plea in this case, or do you want to? Well, do you want to enter a plea in this case? Yes or no?
Here's what I'm trying to explain, yes. Judge. Let me finish my statement, and you'll get my answer, okay?
Well, then get to the point, Mr. Black.
The point is that Mr. Grayless is in the courtroom right now. I'm asking him to meet with Kunzweiler in his office this afternoon, and we can talk about this.
There's nothing to talk about. You either enter a plea or we're set for trial on Monday.
Okay.
I don't know if Mr. Grayless and Mr. Gocher are able to meet. That's not something I need to know. What I'm going to tell you is this. We are set for trial Monday morning at 9 o'clock in the morning. I am ready to start this trial Monday morning. I am telling you to be here Monday morning at 9 o'clock in the morning. If you are not here, I will issue a warrant for your arrest. I will tell you if you want to enter a plea on Monday, I'm happy to do that. But there are two ways this case, well, I guess three. Three options on Monday. One, you come to court, we start trial. Two, you come to court and you enter a plea. Three, you don't come to court and I issue a warrant. That is what is happening on Monday, period. Okay?
I don't have a problem, Judge. I'm going to be there on Monday because I'm a righteous guy.
Mr. Black. What happens between now and Monday morning will depend on you getting with your attorney and talking with Mr. Grayless. But one of those three options is happening on Monday morning. The other thing that I am going to tell you is this. You have the right to be present for your jury trial. However, you have an attorney. Your attorney is going to be the one that is addressing this court. Your attorney is going to be the one that is addressing the jury. Your attorney is the one that will be asking questions of the witnesses on the stand. You will be sitting there next to your attorney and not addressing this court and not talking to the witnesses and not talking to the jury. If you cannot do that, then I will remove you from this courtroom and we will proceed with trial without you.
Well,
Any questions about that?
no, I have no questions about that at all. In fact, I wrote about it, and it's called Ferretta. And I specifically cited the master. It talks about the defense not being the defense's defense. Assistance of counsel is not master servant. And that was specifically quoted in Ferretta. And from that standpoint, I'll leave it at that. I'm not ready to plead today. I would like to get with Mr. Graylis and Mr. Kunzweiler this afternoon as possible. We will defer any resolution of this particular issue that you're asking me about, a blind plea or whatever, right now, and continue that part of it until later. Is that fair enough?
That is acceptable to the court.
Thank you.
We'll have that decision, though, Monday morning. Again, it's one of three things that are happening Monday. So I'm going to go off the record here in a moment. I'm going to give the phone back to your attorney, and your attorney and you can discuss, and Mr. Graylis is in the courtroom. The three of you can discuss matters about meeting, not meeting, but that is not something that the court needs to be involved in. I just wanted you to know what the court is willing to do on what I am calling a blind plea, although I am making it abundantly clear to you that even though it is a blind plea, what I would do in this case, given the facts and circumstances as I am aware of them.
And I understand that, Judge.
Mr. Graylis, anything on behalf of the state before we go off the record?
No.
Mr. Gosher, anything on behalf of the defense before we go off the record?
The only thing I was saying, Your Honor, in response to something like I said, is that I had to get my text and my email during this period of time. He is right, we've not talked about personally, but there is a reason for that. Doing it by email and text is the way that I prefer. That's all I need to say.
Okay. All right. We will be off the record, and Mr. Black, I'm going to hand the phone back to your attorney, and we'll be in recess.
Have a good morning, Judge.
Dang, I gotta hang up now. Bye.
Well, wait a minute.